Welcome to the Computational Antitrust podcast. My name is Thibaut Chappelle. I'm a faculty affiliate at Stanford University Codex Center and the creator of the Computational Antitrust project, exploring how legal informatics can benefit antitrust law. The project gathers over 50 agencies and 35 academics in the advisory board. Each month, we publish an academic article on the subject of computational antitrust. You may find them at computationalantitrust.com. Today, I'm thrilled to be receiving Daryl Lim, who wrote a paper for us on computational antitrust chances of success. Daryl is the professor of law and the director of the Center for Intellectual Property, Information and Privacy Law at the University of Illinois at Chicago John Marshall Law School. Daryl, welcome. How are you doing and where are you based right now?
Well, Thibaut, thanks so much for inviting me. It is a real treat to be here. I have been a follower, admirer of your efforts at Stanford and Codex, and it is a good segue to what I've been doing. So I'm very happy to share my paper and also to be here to speak to you. Physically, I'm in Chicago, and it has been an interesting time. I have pivoted like everybody else online, and I think in some ways I will always remain online. It's a lot easier to connect to people, and I think we can do some interesting things in the online format or in the hybrid format in addition to live events, which I think we may get to later this year or next year.
Well, excellent. And maybe before we get started, I want to ask you a very political question. Are you rooting for Chicago deep dish, or are you more in favor of New York slices?
Well, I'm not really a pizza person. I've tried both. I've enjoyed both, and I would say it like your cup of tea. Would you like it with milk or not? I think there may be some days that you prefer one and not the other. But I'd recommend that you try both.
Okay, well, indeed, I will extend the same recommendation to all of our listeners. But so moving on to the field, which is hopefully a little bit less political still those days, I want to discuss antitrust. Could you take us through your paper and in 2 minutes or so explain what the main message is?
Certainly. So I had framed the paper perhaps provocatively: can computational antitrust succeed? Computational antitrust was, I attribute it to you, Thibaut, because I don't think I've come across that phrase as it's been presented until I looked at your project. I've heard of algorithmic antitrust, I've heard about AI and antitrust, but I think all of this really converges at one point. And this point is, can we move antitrust analysis to the next level? Can we look at antitrust the same way that we did with fresh eyes when we first introduced economics into antitrust law, and not be dependent on swings in ideology or heuristics, as judges, particularly generalist judges, have to do, because it is grown to such a level of sophistication and complexity in having to analyze markets, in having to predict effects, sometimes forcibly because the legislation, like Section 7 of the Clayton Act, requires, sometimes because of technological progress. And so, as a result of that, the idiosyncrasies of judges, and I'm sure as we will get to, of different ideologies, creep in. It makes precedent difficult, and particularly in a field like antitrust law that is so heavily judge made. It's not good for business certainty. It's not good for policy making. And I think if we can have a better ballast and anchor in the form of the big data, in the form of the computational powers that we now use and in some ways take for granted in so many other areas, I think we'll all be better off. So that was the thinking behind my paper. And the rest of it really helps to identify, flesh out some of the key areas where this could be helpful and some of the obstacles, which I think anybody trying to propose this and implement this will have to face.
Yes, and so it seems that we are very much on the same page, which is that computational antitrust may actually benefit both the agencies and the companies, and so in the end, the consumer. Of course, not always on the case by case basis, because if you are able to come up with some evidence proving that a practice is anti-competitive, I very much understand why a company or vice versa, a competition agency will be happy or unhappy. But still, it looks like if we take a step back, actually it will benefit all of the players playing the antitrust game. So, in the paper, you first mentioned the existence of a risk when theory and empirical information are inadequate. And this immediately, of course, made me think about several books that I've read recently. One being Nassim Taleb's Black Swan, but another one also, which is Radical Uncertainty by Kay and King. And this indeed is a very important risk. And I believe that neglecting that risk could lead antitrust agencies and courts to use computational tools without considering the limits and therefore only give room to a computable outcome. To address that, you propose three concrete objectives for computational antitrust. First, you say that it should be used for creating law and facts, and more specifically, to take the most out of agencies and courts' own case law. So, could you explain what you have in mind in that regard?
Oh, thanks for that question. So, when you said that both of us are on the same page, I think that's absolutely right. We think we are both apostles of the same gospel. Uh, but at the same time, I'm sure as you would have encountered people who raise criticism and questions about this, uh, see this almost as if it's a perfect product or this is a flawless proposition. No, I think there are many issues with it. But I think former President Barack Obama said it best when he was talking about his new book, The Promised Land. He said, and if I may quote this, because even though we may not get there in our lifetimes, although I'm a little bit more optimistic in this case than he is on what he was talking about, and even if we experience hardships and disappointments along the way, that at least I still have faith that we can create a more perfect union, not a perfect union, but a more perfect union. And so I think the key idea here is now we're not creating perfect antitrust. We are trying to create a more perfect way of approaching antitrust than the way that we have. Now, when we talk about Nassim Taleb's Black Swan, I think it's important to actually realize that he was talking about how old data sometimes is insufficient to enable users to predict new events. And in that regard, I would actually push back a little bit on your proposition that agencies would be obsessed with the data and then uh, maybe throw their discretion to the wind. Because if you ask any human being, I think they would be quite eager to exercise their discretion whenever they can. In fact, if you take a realist view of why judges become judges rather than big time partners, it's because they want to do justice. And so, at most, I see the computational side of antitrust as being a tool, as we use many of the tools that are usually invisible to us when we do shopping on Amazon or when we go on TikTok. And they may give us recommendations and they may curate and they may synthesize the data, but ultimately what we have are options. And what that means, therefore, is we recognize that ultimately the person in the driver's seat will still be the human being, but that the human being can make better decisions because they have better tools. When we talk about the first aspect that you mentioned about curating facts and law, uh, what inspired me to think about it was actually case content analysis. That as legal scholars we've been doing for a long time. In fact, Stanford, where your project is housed, is one of the pioneers and leaders in this regard. And we do it the old-fashioned way. We may manually code cases. We may try to determine um, what they call the stampeding factors in cases might be. But that's a very time-consuming and quite imperfect way. And normally you do it in a very small scale. With computational antitrust, you can do it in a much bigger scale, much more ambitious, and you can do it in a much more sophisticated way. It's a conversation that immediately brings to fore the fact that unlike how we traditionally like to live siloed academic lives, we have to involve a village. We have to bring in data scientists. We have to bring in people from other disciplines, economists, of course, and to interpret, to understand what the goals are and the concepts are. Antitrust is well positioned for that because it already has an ecosystem where economists and lawyers talk to each other. Maybe not as often and as much as either side would have liked, but I think it gives us a good prototype to work with. And then you can debate and discuss how you're going to deal with cases that may be economically suspect, 50 years, decided 50 years ago, and now part of the data set, how you might curate between the levels of the courts, how you might deal with dissents. These are all important questions, but at least it then gives you a platform to discuss methods and the engineering rather than be hung up over the tides of ideology, whether it's Chicagoan or neo-Brandesian or post-Chicago. These are important debates, but these should not be the only debates. The engineering is just as important as the architecture. And right here, what we're trying to do with computational antitrust, I should say, I think, because you're the head priest, and all of us are just fellow passengers on this journey, is trying to bring a different and complementary asset into the discussion.
So, I mean, first of all, thank you very much. But I should say that I feel like being a very small passenger on the big train. But to take the train analogy, which I like very much, we indeed have on the antitrust train, we have so far lawyers and economists. And we know it hasn't been always an easy relationship. But now we need a third type of passenger. And this passenger is a computer scientist or a data scientist. So I was wondering which of the two, out of the lawyers and the economists, would think that the computer scientist is not welcome on the train? Or put it differently, which of the lawyers and economists you think will actually send an invitation to computer scientists to become a passenger on the antitrust train?
Well, I think you might have some pushback initially, perhaps as there was with economists and lawyers. And I don't know if it's still the case, but the common complaint that I hear from economists that they are treated as second-class citizens, and their views are not quite taken as seriously as they should be. With data scientists, I think the fact that the economists have blazed the trail might make it easier. I think the fact that very quickly lawyers will find that even though they may want to make the decisions, they may not have the ability to synthesize just the overwhelming velocity and volume of the data that is now typical in an antitrust case. And people take for granted that antitrust cases should last for many years, but that doesn't necessarily have to be the case. And one of the things which big data has already done is it really has shrunk and compressed the time that things could and used to be done in the past. So in this new age where things have to move much more quickly, you need an all hands on board approach. And the countries and the firms and the industries that can embrace that will push ahead. And I think the natural competitive process, which we are also concerned about with antitrust law, should break down these traditional silos, I think, sooner rather than later.
But so thinking about what you say, and I have to admit that I'm convinced, in fact, that indeed, at the end of the day, human beings want to be able to take the decision they want. So they will be using some of the facts and the data in a certain way. And I haven't thought about it this way, but so let me ask you the following question, because in the paper you do say that computational antitrust could also lead to creating more per se rules of illegality or legality. And so, in my view, but of course, this is just an opinion based on where we are right now in the field, but it seems to me that quite the opposite actually could happen. So let me explain. It seems to me that the more you actually document a practice, the more you may realize that the practice is actually sometimes pro or anti-competitive. And when teaching antitrust or competition law to my students, I always try to come up with an example for the very first class, where I will give them a good example of a practice that will be always pro-competitive and another practice that will be always anti-competitive. and it is actually nearly impossible to come up with such an example. So it seems to me that computational antitrust could actually foster this reality and lead us to realize that it is actually more complex than what we thought. So I'm wondering, and I'm curious to hear you on that. Which practices do you have in mind when you say that more per se categories will be created, and put differently, which of those practices would you like to document using computational tools?
Yeah, I think that's a great point, Thibault. And I would say, first of all, that it's not necessarily either or. It can be both. I think that the point that you make is a very good one. Uh, it all depends. It's not mutually exclusive. There are some instances, and I think many, which you would still have to uh, apply the rule of reason. And I think there's a lot of merit in being able to do that. But the rule of reason, if you look at how commentators and even judges view it, is it's a black box a lot of the time. Supreme Court, many Justice Breyer, Chief Justice Roberts has said so. And I don't think judges enjoy having to do that balancing of pro-competitive benefits against anti-competitive effects. In every case, it's tiresome, and it leads to sometimes capricious results. If you look at how, for example, the district court in Qualcomm uh, analyzed facts and very thoroughly, many couple of hundred pages, I think, of fact finding and a fairly terse and brief judgment, completely overturning the district court's findings on appeal in the Ninth Circuit in Qualcomm. You see a very volatile strain of ideology at play. I think you look at how the different circuits were split prior to the FTC versus activist decision. You also see how that breeds a lot of uncertainty where judges lean ultimately on their view of patent rights or commercial freedom to contract in determining very fundamental, important issues of access to health and medicine and being willing in some cases to actively disregard settled precedent on market division, for example. So I think you want to try to limit that type of wild ideological swings as much as possible, where you can say, here's the data, why it's not a good idea. Now, why were per se rules introduced in the first place? Because judges ultimately uh, are not equipped to make these decisions. And in order to have uniformity, and uniformity is actually highly prized. Just look at the Court of Appeals for the Federal Circuit and why it was created to deal with patent disputes. It makes it a lot easier for them to do it. They just have to find the conduct, and they can assume that even if there are pro-competitive benefits, it is more likely than not that the anti-competitive effects are severe, whether it's price fixing, whether it's bid rigging, in order to prohibit the conduct. Now, are we talking about, therefore, having large swaths of per se rules? No. I think what you would have is in subcategories of, say, a particular type of refusal to license, or a particular type of tying agreement, or a particular type of exclusive dealing agreement, that you could allow a judge with fair amount of confidence to say this should be per se. And then it will be up to the parties to try to distinguish the normal common law way in trying to distinguish precedent. But at least it gives judges that option, that tool, rather than merely leaning on heuristics. And I think on appeal, whether from the district court to the appeals, or from the appeals court to the Supreme Court, or whether in the court of public opinion, you are able to debate these issues a little bit more transparently.
Okay, so at the end of the day, what we may have is indeed some per se rules when it comes to certain subtypes of practices. So something very specific, but potentially for the broader categories of antitrust, what we may have is a more structured rule of reason. Because when we hear rule of reason, of course, we think naturally about the balancing of pro and anti-competitive effects, but it might be that you want to apply another legality test, and for other types of tests, computational tools could actually be very helpful and in providing the necessary data to get to the right analysis.
Yes, in fact, if I may just quickly add one more point, the quick look approach itself recognizes that burden shifting. If you look at Senator Amy Klobuchar's proposed bill, and in fact, what's been happening, I think, in Germany with respect to data portability, there is that recognition that in some instances that presumptions should be in play. Therefore, it's not that revolutionary a concept, but one I think that can be better aided with data.
So this leads me to the second objective that you assign to computational antitrust. And you say that it should be to futurecast quiller acquisitions. Currently, and here I quote you, retrospectives analysis are very much primitive, end of quotes. And for that reason, you say that it actually leads courts and agencies to guess merger outcome rather than making truly informed decisions. And this, you explain, is because they do not have the right data nor the right tool. So my question to you is actually twofold. First, which data should they be asking for or scraping or tracking? And how should they do that? And second, once they have the data necessary to actually feed computational tools, which of those tools would you like them to explore? And you mentioned actually quite a few in your paper, but I'll be curious to hear you about one of those.
Right. So on your first question, what data should they ask, scrape, and how to do that? Of course, they could start with what is generally been used. You could use price matrices. You could use barriers to entry. You could look at adjacent markets and nascent competition and so on. And there are well-established theories, and people have already been doing that. But the thing about AI, if you look at how AlphaGo Zero, I think, was able to train itself and able to maximize a preset reward without the need for continual human supervision, and able to look at a particular goal and maximize that goal with different sacrifices, which human beings might not think about. You are able to, in a very dynamic environment, consider not things in a rather linear way, but in a multifaceted, holistic way, which I think brings us to a whole new dimension of being able to take upon ourselves the very difficult task of future casting killer acquisitions, which, if you think about it in the normal case of Section 1, Section 2 anti-competitive agreements or monopolization, you are considering one counterfactual. What would have happened without that agreement or without that conduct? With mergers, you are considering two counterfactuals, right? Two parties merging, what would have the consequences of that be? And then with killer acquisitions, you're adding further levels of complexity. So one way to deal with it is the way that the Chicago School might counsel, which is trust the market. We don't know this, how to deal with this. We're only going to make a mess of it. The other is say, hold on, maybe we have a better way to deal with it. Maybe not perfectly, but it's not quite the same as it was 20 years ago. We are at a different place, and we should be using the tools that we have at hand.
Well, and if I may, it seems to me that there is actually a third way, which will be to prohibit mergers, to prohibit all of the big tech companies or dominant company from acquiring other companies. And if you do that, well, it might be a way, indeed, by way of ex ante enforcement or ruling to get rid of the need for more concrete and specific information as to the way market functions or the counterfactual. But indeed, coming back to our idea of computational antitrust, and if you believe that the trial is a discovery procedure leading to the truth, or actually to get closer to the truth, then what you want is to provide agencies and courts, but also companies, with the right tools so that they actually may have a way to document and to support their analysis and argumentation. And so this brings me to the third objective that you assign to computational antitrust, which is to help the plaintiffs. And as you write, indeed, under Chicago's rule, plaintiffs lose in an overwhelming majority of cases. And this is because of procedural issues, but also substantive barriers to their point. And you explained that at the end of the day, the Chicago School actually never developed a reliable way to quantify the risk of false positive and false negative on the other end. And so, indeed, it seems to me that it is more of an ideology than a scientific method. And so, I was wondering if you could actually take us through that argument and explain where you see computational tools playing a role when it comes to getting closer to the truth, or at least to gather some facts and patterns when it comes to anti-competitive practices.
Right. So why is there such a great level of hostility against plaintiffs? I think we have to take a step back and recognize that it was done out of caution. It was done out of goodwill. There was indeed the structuralist view that big is bad, and therefore many otherwise pro-competitive conduct cases were being unfairly penalized. And so the Chicago School did do a good job in increasing the rigor in that analysis. But I think most academics also recognize that the Chicago School has overshot its mark. And the pushback to that is neo-Brandisian, because they see uh, disparate wages, and they want to go back to this idea of atomicism, where you have many small competitors. But is that the reality of how the marketplace today works, with globalization, with the conglomeration of digital platforms? Uh, is it better to have 10 little Amazons, or maybe one or two or three that is regulated in a more transparent way? And to have low levels of contestability for antitrust plaintiffs, in particular private plaintiffs, but also government agencies. One barrier that private plaintiffs need to cross is this idea of antitrust injury. How do you prove an antitrust injury? This is where I think computational antitrust can very helpfully show simulations of harm. And if you look at work by Michael Carey and others that show how judges seem to be systematically or systemically prejudiced against plaintiffs, I think that comes from a certain uh, worry in their ability to pick out these instances of anti-competitive harm. But I think if you can address that to the courts in a more convincing manner, it will definitely improve the ability to push the narrative, just like they would with any other type of evidence. So again, it goes back to the idea this is not, in a sense, revolutionary in what they can, in the way that you are giving evidence. It's just that the evidence that you have is new and revolutionary type of evidence, which I hope that both private parties, agencies, and the courts would embrace.
Well, this is really truly fascinating to me because, of course, coming from my European background, what I thought when thinking about computational antitrust was naturally the public enforcement part of it. It represents more than 90% of all of our cases, so I can see very much how relevant it might be to agencies to be able to use some of those tools. But what indeed might be considered in the US is how computational tools may actually also play a role when it comes to the private enforcement part. And there, I do have a question because it seems to me that if you are an agency, I can understand how you could actually develop some of those tools and feed the tools and improve your practice and enforcement capacities. However, if you are a startup and you to take your example in Amazon are trying to if you are trying to introduce a case against Amazon, I can understand that it might actually be harder for you to fight in a game where computational antitrust exists, because it might be easy for Amazon to actually hire a bunch of computer scientists and data scientists, but it might be, on the other hand, harder for a startup to do so. So, how do you envision that, and where do you think is the future of private enforcement going when it comes to U.S. Antitrust?
Well, that imbalance of power is there in any case, even in the industrial age. Folks that were going up against Standard Oil had much fewer resources. But ultimately, why did it prevail? I think the zeitgeist of the age was such that they were looking for a solution. How do you, as a little guy, come up against Amazon Well, I think this is where it goes to the legal system. Is the legal system, I can't speak for every legal system, but proper functioning legal system should allow that sort of imbalance of power to be corrected. Another institutional tool is the agencies. And in the United States, you have not one but two, and we can certainly talk about what difference the FTC can make compared to the DOJ. And you've got state attorneys general. So I think there's a fairly structurally robust set of tools to muster in favor of the plaintiff's course of action. I'm not too worried about the Amazons going unchecked. If you look at what's going on in the current investigations, it seems like folks like Amazon are against the back wall. Even Google recently in Australia and now some other places have been subject to antitrust action for not paying for copyrighted content. So I think it's a different age. I think in this age, it would be imperative to find the right balance because it's just as easy that you swing too far to the other side. And again, I think if you have data and you have data analytics, that helps you to at least have more of a common ground than simply ideology. Because if you go just with ideology, look what happened with the French Revolution. Heads will start to roll.
Yes, I mean, we could be talking about that, but being French, because the grass is always greener elsewhere. I want to talk about the US, and so what I would like to do now is to move on part two of your article, which I enjoyed very much, and this again is another of my many biases. Because what you do there is that you actually discuss several of the criticisms that one could make to computational antitrust, and that we will hear for sure in the coming months and years. And you explain why they don't really stand when comparing computational antitrust to antitrust without computation. So evidently, I'm just a tiny bit biased because for reasons that you will understand. But there is one point that I would like to discuss with you more specifically. You say that those seeking transparency may actually find accountability both a more realistic and helpful goal, as indeed accountability attempts to explain what both the algorithms and their users seek to achieve. And that to me is indeed central. And here I would like to introduce a distinction between supervised machine learning and unsupervised machine learning for reasons that I want to explain. When it comes to supervised machine learning, as we know, the idea is that you actually give the input, which is the data, and you actually label the data in a way so that the machine can actually reach a certain output. And you train the machine, and hopefully by giving some new data, the machine will achieve the same output. So there, I understand very much how accountability can actually be working, because you are the one in charge of choosing the data and also training the machine in a certain way. So you control, in a sense, both the methods and also the outcome. However, when it comes to unsupervised machine learning, where what you do is that you only give the data and the machine will figure it out by itself, whatever it means, well, here what you control is only the results, right? You can choose to use the result or to disregard the result. But when it comes to the method, it is actually obscure, which has been labeled as being the black box issue. So I'm wondering, how do you envision that accountability system when it comes especially to unsupervised machine learning?
Right. So let me first say that I think bias is going to exist all throughout. There's going to be bias in the data itself. We talked about how the case law itself could be biased. There's going to be bias in the selection of the data to train the algorithm. And there's going to be bias in the interpretation of the results that's produced by the algorithm. You can't run away from bias because that's how we navigate the world, the heuristics, and any number of books on behavioral economics have been written about it in that sense. What can you do, therefore, in a world that you can't run away from bias? And in fact, bias may be a good and necessary thing in some instances. And for that, I would refer you to some comments that former Commissioner Rebecca Slaughter made. Now I think she's chair of the FTC. And she made some important comments recognizing that sometimes bias can be good and necessary. How then, in a case of unsupervised machine learning, do you have that level of accountability? And as you rightly pointed out, the quest here is not for transparency, because the reality of how AI works is that there's going to be some element of it being a black box. And in fact, it's precisely what gives you those wonderful, unexpected results. So with accountability, you can fall back on legal regimes like anti-discriminatory laws, for example, that have for decades, if not longer, had a checklists and rules of thumbs and standards by which to check these things. Institutionally, you could have ethics committees, you should have regulatory oversight committees, ombudsmans, both at the corporate level within the institutions. Although if you look at Google, they may have, that may be a negative example of how it should not work. But I think they are trying. And I think if you look at how you can do it at a community level, at a national level, even at an international level with best codes of conduct. I know Singapore, for example, has been quite successful in pushing out its AI governance standards. These are important ways to engage the community beyond antitrust law, but in a way which brings confidence to the antitrust community that this is a tool which is well regulated. There are ISO standards, if you like, internationally recognized, and we can be confident that while we may not get the perfect answer, the answers are defensible and the products and the processes are robust. And I think that's going to already take the conversation a huge step forward from where we are right now.
So in turns, it means that we not only have the issues of competition antitrust, but also we have to face the issues coming with AI. I guess the great news is that we are seeing lots of papers coming out those days discussing the all of the issues of discrimination, for instance, coming with AI. The bad news is that we have to be discussing those issues even though we are in the field of antitrust. It's not a bad news that we have to discuss the issues in and of itself, but it's a bad news because it means that they should be considered. So this actually leads me to one of your sentence in the paper, because I want to finish that conversation on a positive note. And you write that, and I quote, computational antitrust could supercharge the velocity of litigation and make swift justice work for the benefit of all. And so that, in my view, is extremely well put. And so I'm wondering the following. Should you tomorrow be the head of the FTC, where would you start when it comes to computational antitrust? And also taking a step back, where do you think we will be in 5 years from now in terms of what is possible to achieve thanks to computational tools?
Okay. So let me take your questions in reverse order from the 5-year point. So I would start by saying it's tough enough, as a baseball player in America called Yogi Berra said, to make predictions, especially about the future. Therefore, it will be difficult for me to say where things are, but I am optimistic. And let me explain why that's the case. Technology is improving at a breakneck speed in very encouraging ways. 5 years ago, we would not be having this conversation about even applying AI to antitrust law. In fact, 5 years ago, the only point in which AI came up in antitrust issues was as a threat in facilitating collusive price fixing. Now we're actually looking at it as a positive way. I think that's revolutionary in itself. But also in 2021, MIT researchers have developed flexible algorithms that can learn on the job, what they call liquid networks. And what they can do is they can change the equations, they can adapt to new data inputs, but most excitingly, they can do it in a way that makes it interpretable by changing a representation of a neuron. I think I am slowly getting out of my depth, but with different differential equations, and what the reports say is that data scientists can then explore complexity, but at the same time make it explainable. So it's no longer necessarily a trade-off between that sophistication and computational power and explainability or accountability. So I see the concerns in some of these areas not necessarily disappearing, but being alleviated. And I think that's an important point of progress.
Yes, and so if I may, very briefly, this reminds me of what OpenAI disclosed not so long ago, which is the API named GPT number 3. And indeed, I don't know if you've seen the demos, but what they've done is that they actually use that API to provide some computer language, and I think they use Python, but it might be another one, and the API will actually translate that into the language of your choice. So it could be English, French, Italian, or whatever you prefer. And so it's very interesting in my view, because it means that human beings might be able to understand the technology using another technology. So in a way, we may catch up, not by trying to escape from technology, but by embracing other technologies, so to understand the ecosystem in a better way. So this again, to me, is going in a positive direction. But that being said, I do want to hear what will be your program tomorrow, should you again become the head of the FTC.
Well, first of all, I would not presume to be even distantly considered anywhere close to being in a position of power within the US government.
Well,
But
watch out. You
let
never
me
know. You may receive a phone call tomorrow.
let me just talk about what an important role the FTC can play in this. The FTC really can be a test bed for the AI revolution. In the same way that you and your colleagues at Stanford are doing this fantastic work, they are in the government and they have the uh, regulatory tools to do that. They have 6B powers. In fact, the FTC was created as an agency to study how markets work and to provide the government with the advice that they need in these sector specific areas in emerging trends and so on. And they have done very good work with respect to pay for delay, with respect to standard essential patents, and a whole host of other areas. AI is not new to them. I think in 2016, they actually produced a report on AI. But this is new. This is something that I think may not be on the forefront of their current priorities, but I think they should think about their comparative advantage that they have relative not just to the DOJ, but to other antitrust agencies in the world that do not have that research and rulemaking type of authority that they have. And in this regard, I think the FTC, as a beacon for United States leadership, thought leadership, and antitrust law, can make a real difference. For the most part, people look at the US and say the US is an outlier in antitrust law. We really should be looking at Europe at how to enforce antitrust robustly. And I think that comment is really in part due to the lax antitrust enforcement that the Chicago school has caused nationally. But now that you can have yes, but this is what we can do better, you might have a real chance to turn the tide around. And the FTC can be able to be at the forefront of that if, like you and your colleagues, it marshals the resources, it engages stakeholders from across the board, and it gets the buy-in. And eventually, I think you will start to see the first few cases as interest percolates and people want to get ahead in the game.
Well, so at the end of the day, it means that computational antitrust might be enabled because of legal design and because of the investigative power and the structure, the legal structure of different agencies, which really is tying the subject together and proves that lawyers have a role to play, even when it comes to such a technical field. So again, thank you for leaving us on such a positive note, and thank you very much for a fascinating discussion. What I want to remind everyone of is that your article is available on our website, computationalantitrust.com. Well, again, thank you very much. Take care. I hope to see you in Chicago very soon. Bye-bye.